Hey, it's Matt Storms. In a previous video, I provided an overview of the top 13 mistakes of emerging technology-based companies. In this video, what I'm going to do is go more in depth about mistake number 5, and that is not using or signing agreements that lock up intellectual property. I'll give you a couple of examples of situations that have arisen more than once with the companies that we work with or that I'm aware of. So the first example is typically when a new employee comes on board, they're asked to sign an invention assignments agreement. Sometimes through omission or through a process where that individual employee does not want to sign something, that agreement for whatever reason doesn't get signed. We have a recent situation where a company was in the process of being sold. The buyer was going through diligence to ensure that each of the key employees had invention assignment agreements and discovered that one had not. And then when they followed up with that employee to see if they would sign the agreement, the employee refused. This ended up being a situation where the buyer felt that having that agreement in place was crucial to the acquisition. As a result, the buyer ended up having to pay directly that employee. And from the seller side, meaning the startup company that was selling, they actually had a reduction in the company's sale price because the buyer was not willing to pay more, and it ended up being a situation where part of the purchase price effectively went to that employee who had refused to sign the invention assignment agreement. Another situation is that companies, especially at the startup stage, will bring in experts or assistants, let's say with engineering, to refine our product, to, in essence, it could be to build out a website or components of a particular offering. They hire contractors or companies that have that expertise to effectively assist the startup with whatever is needed. There's a common understanding that if you pay that person or company to do that work, that the recipient of that work owns it, the underlying product that's being produced. Unfortunately, that's not how the intellectual property laws work in most cases. When you have somebody who is an independent contractor, whether it's an individual or entity, and they create something from an intellectual property perspective, in most situations, that person retains ownership, even if that person or entity is paid for that product. That's the importance of having an actual agreement in place that assigns that work product and the underlying intellectual property that's been created as a result of that work product to the company that paid for it. This comes up also in the sale process, where the buyer will, in essence, take a look at the key components of the intellectual property that was created in the underlying technology of the business. And if it identifies or can't find something that has a proper invention assignment component to that, it ends up being a point of the underlying deal. So at the end of the day, what's important here is to have the intellectual property agreements signed and in place, and it applies to both employees and contractors. So that helps. Thanks.